Good evening. So welcome to today's revision lesson. So this is lesson number 8, I suppose. So we're going to do land law tonight, and there is something that I started yesterday. Those who were able to attend yesterday's session, and that is to say that in every session we will try and start with a question teaser, as it were. So tonight we are discussing a very basic concept in the land law. So, and that question, which we are using as a teaser, is that critically examine the concept of no-ownerless land in relation to Ghana's customary land law, right? No-ownerless land in relation to Ghana's customary land law. So that is a very basic thing in land law. So I would like you to think about that question. Critically examine the concept of no-ownerless land in relation to Ghana's customary land law. So we will go to the topic, although I have provided a sketch of what will be good points to be reflected in an answer to make a good mark. So a question like this, the aim is to find out whether you are familiar with one of the most basic, one of the most elementary aspects of land law in Ghana. So that if you say you've learned land law, there are some doctrines which develop at very early stage when various writers started writing. Mensa Sarbah, Ollennu, J.B. Dankwa, and now Dr. S.K.B. Asante, and later Professor Kluje, and all that. When they started writing on customary land law, an issue which had actually been very topical during the colonial era, as whether some of the lands in Ghana were just there and did not belong to anyone, crystallized into this doctrine of no-ownerless land. So that is what the question actually seeks to test your knowledge on. And you also note that a good introduction will have to be provided, and the good introduction certainly will need to explain your understanding of what the question is inviting you to do, and then for you to also provide a roadmap of what you are going to actually explore or discuss in the question. So that is quite pertinent. So structure, as I keep telling you, is very important. In every question, you must have a good structure. And a good structure will definitely be reflected in your introduction. So that is where you give like the roadmap, the guide, which is going to govern how you write the answer. So points to discuss will certainly include you explain ownership and the possession in customary land law. You outline the range of customary law interests in land. The Allodial, customary freehold, customary tenancies, customary threat, hypothecation, and so on. And then because we have like the Land Act, right? The Land Act 2020, Act 10, 36. You must always go back to section 1 of Act 1036 and then list the interests which are in land over there, because now that is the statutory enumeration of the range of interests available in land law in Ghana. Then, so having done that, you need to explain the concept of a no-ownerless land. we'll be discussing that pretty soon, but I'm just giving like the sketch of what you will need to be thinking about. And then again, you also need to tell the examiner about the historical context of the concept. The no-ownerless land did not just come out of the blue. It was because of the Public Lands Bill of 1887. When the colonial administration, of course, which is a representative of the monarch in Britain, wanted to vest all lands which had not been claimed by anybody as his own or her own or belonging to any family, to vest all those lands in the crown, make them, if you like, the state land, as it were. And it was within that era that we have the intelligentsia, that is educated, the elite at the time, who actually organized themselves into the Aborigines Right Protection Society and actually marshal various arguments, and they disagreed and so on. And of course, not only that, there also like case law, which also confirm the doctrine of no-ownerless land. And later on, Rosakuje will also come onto the scene and try to refute the validity of the claim that we have no ownerless land in Ghana. And in his famous work, Law of Property, he will try and develop the argument that he has evidence from his research in around the Wiapa region to suggest that, as a matter of fact, there are some portions of land which had been lying there, and no family, no chief lay claim to it. So he wants to opine that it is incorrect to say that we have no ownerless land. Then in fact, there are ownerless land. That is his argument. Good. So roughly, that is what is expected of you if you have a question like that. So let us keep that in mind. So as I said, we would like to briefly explain that concept. So the doctrine of no ownerless land is mouthful. Now, if you look at a very important work on customary land law by Mr. Justice Ollennu, known as the Ollennu Principles of Customary Land Law in Ghana, published in 1962, he makes the statement that the first basic principle of our customary law is that there is no land in Ghana without an owner. Every inch of land in Ghana is vested in somebody. So this was Ollennu's thesis, or his very important assertion. And it was not just Ollennu who was just, it wasn't just Ollennu who was actually just saying that, but some other writers, going back to John Mensa Sarbah and so on, had all made some allusions to this no ownerless land. So let's keep that in mind. And so, of course, Mensa Sarbah's work is not 1987. That is a typo, so just forget about that. And again,
hey, instigate emergency by Benedict.
Please, can you mute yourself? Doreen, please mute yourself. Right, thank you. Yeah, so we have a lot of literature in which the concept has been alluded to as I indicated. Then quite apart from the writing of the jurists or scholars, we also have case law, which makes no reference to the no-ownerless land. So look at the Wiapa and the Solomon, a 1905 decision. Those of you who have like the Josiah-Aryeh's land law, either the volume 1 or the volume 2, some of these old cases, as well as Mr. Parmijan. If you have Mr. Parmijan's books, these cases are also reflected over there. So in Wiapa versus Solomon, for example, the point was made, and I quote from page 39 of Dr. Josiah-Aryeh's Property Law of Ghana. So I'm quoting from a Wiapa and Solomon quote. Though the principle obtains that all the owned land under the authority of Paramount Stool belongs to such stool, in practice, this is much modified. Each subordinate stool has attached to it a large portion of land, apparently carved out of the territory originally belonging to the Paramount Stool. Similarly, families have large tracts of land carved out of the subordinate stool lands. And finally, we get down to individuals with private ownership of particular parts of the family land. And or private individuals may have part of the stool land not being family land. Any unoccupied land within the recognized boundaries of subordinate stool land or family land will, of course, belong to the subordinate stool or the family, as the case might be. But any unoccupied land not being a part of the land of a subordinate stool or family or a private person will be attached to the paramount stool, unquote. So the essence of Wiapa and Solomon, which was also repeated in the case of Ababio and Kanga, and then Ofori Atta and Atta, and even Ohimen and Adjei, is to suggest that it is not possible in our country for someone to say that there's a land over there which does not belong to anyone, for that matter, is going to possess it or settle on it, because the authorities, in terms of the judicial dicta and also the writing of these juries, suggest that every land belongs to either a stool, a sub-stool, a family, and so on. So that is the most important point which is being made. Now, the implication of this doctrine of no-ownerless land is that it certainly had the practical advantage of preventing lawlessness in acquisition of land and also ensures order in land development. Because of the doctrine of no-ownerless land, if you are minded of cultivating or developing any land, you are put on notice from the very start that wherever you want to go in Ghana and cultivate or develop the land, you must find out who the land belongs to, regardless of the type of interest, that the Allodial title or usufructuary interest, customary tenancy, or whatever. You must find out who it belongs to. So that ensures some kind of, if you like, order. Because just imagine, factually, if we were just to go by the fact that, yes, you look around and we have a whole stretch of land which has never been cultivated or developed, and for that matter, does not belong to anyone, then you just rush there, you want to settle on it, another person wants to come, and so on and so forth. You can imagine the chaos which we have. And I'm sure the chaos we have will even be more chaotic than the multiple sale of land that we have, which the Land Act 2020 Act 1036 is trying to also address. So let's keep that in mind. And as I said, we cannot finish talking about no ownerless land without also being aware of the attack which Professor Kluje sought to visit upon the doctrine. In a very important article that he wrote, University of Ghana Law Journal in 1974, which was titled The Ownerless Lands of Ghana. So you look at it, the title itself has launched the attack, The Ownerless Lands of Ghana. So trying to say that, yes, there are ownerless lands in Ghana, and it is not correct to propound the doctrine of no ownerless land. So that was his argument. And so Professor Kluje will contend that the doctrine of no ownerless land appeared to have been originated as a political argument against colonial governments. As I told you, when the colonial government sought to vest lands which were not actually being occupied in the crown, like in the government, and the intelligentsia or the elites mobilized, and then they sought to resist that bill in the move by the government. So Professor Kuja was saying that, yes, that was a political reaction, but it was not grounded in any empirical data, not grounded in any research. So it's not the case, trying to say that it's not the case that those who propounded that doctrine had actually conducted the survey and come up with the hard evidence that as a matter of verifiable data, we don't have any land which is not owned. So that was the basis of the previous attack. And that is why he also said that even if we put the writing of jurists like the Mensa Sarbah and co, who wrote the Fanti Customary land law, if you put all those writings aside, right, and we want to concentrate on the judicial foundation of the doctrine of no ownerless land. Now, the authorities which we cited, the Wiapa and Solomon and so on, Kluje will argue that those supposed judicial pronouncements on the doctrine were obiter dictum, and they were never the ratio. And because they were never like the ratio, and of course, for purposes of judicial precedent and stare decisis, it is the ratio decidendi, the binding part of the decision, which has a precedential value. And for that matter, Kluje will say that since those statements we've quoted, supposedly being the articulation of the no ownerless land in the case law, was just, side comment, so to speak, or what lawyers would call like obiter dicta. And for that matter, it is not well grounded and so on. And of course, he also criticized all other jurists as having made sweeping statements regarding the existence of no ownerless land doctrine in Ghana when they have also not done any research. So it's just like a mere statement, not based upon any findings from any research. That's the point that he was making. And Kluje will try to say that, okay, I have an evidence of ownerless land, which is from somewhere in Ghana, and that is from somewhere in Volta region. And for that matter, what you are saying is not really sustainable. Yeah, so let us keep that in mind. And I will pause here and take any question that you have on what we have done before I draw down the curtain for tonight. Yeah, so just before we go, let me remind you that the minimum you can do for yourself as far as the land law is concerned, okay, you must get the Act 1036. Now, if you look at the exams questions which have come in the entrance examination, I think of course, I think if you look at the question which was supposedly leak question and then was cancelled, I think that there was a land law question, if my memory serves me right there. And that would have been like the first ever land law question post enactment of Act 1036. In other words, since Act 1036 was enacted, we have never had any land law question in your examination. Now, previously, students were taking solace in the fact that, oh, the Land Act is a new legislation, so examiners will not worry themselves about it. But now, we are in 2023, right? Nearly 3 years since it was passed. And that is the law in Ghana. So I would say that on your own, start from section 1, right? Start from section 1 and read every provision up to the very end. In addition to all the textbook discussions and so on, and the ones that we'll be discussing here. So just about 283 provisions is not a lot. So the suggestion is that if you take enactment, every enactment has got its interpretation side, okay? So the interpretation side will define and clarify certain concepts or terminologies which are used in the Act. So for the Land Act, for example, the interpretation section, section 281, is the main interpretation section, although there are many interpretation sections within some of the part, but for the entire enactment is section 281. So I will advise you to first read section 281, and then having finished reading section 281, you come back to section 1. So next time we come to do land law, we'll discuss interest in land, and especially we'll be raising the question as to whether some of the customary land law interests, they have been significantly affected by provisions of the Act 1036. So we'll be looking at that. Okay, so in absence of any issues, we draw the curtain down here. So have a very good night.